Previous speaker for his contribution and a number of the comments that he made. One of them was that this is a technical piece of legislation, and it is. And it's going to receive the support, as I understand it, from across the House, and so it should. Because all of us would agree that the offender who finds himself in custody and then through some other circumstance finds himself with access to a significant amount of money should be forced to pay his victims out first, or at least his victims should have the opportunity to make a claim against that newfound wealth, no matter how it's achieved. Unfortunately, if he happens to win it in lotto, they'll have to go through a protracted court proceedings to be able to get their mitts on any money that he may have. But under this situation, a victim has the ability to make a claim before the Victim Special Claims Tribunal and to be able to access that money. This bill is coming to the Justice and Electoral Committee, and I just want to take a moment to thank members of that committee who are in the chamber tonight who have served on it from time to time. And I want to point out that that committee this is the 17th piece of legislation that's come before that committee over the term of this government, and 12 have exited and been reported back to the House. And we'd just like to pat ourselves on the back for a moment and say that's more than any other select committee that's sitting within the House. So we look forward to discussing these matters as they come in front of us. The fact is that it is the piece of legislation that just shuts another door. And what I'm mindful of is that over the course of this government and previous governments, we've shut a number of doors in respect of those who find themselves in custody. And what we also know from experience and from our learning over generations is that a number of people who find themselves as offenders and quite rightly behind bars at some stage found themselves as victims too. And what we must stop doing as a civilised society is to close our minds to that. We need to address those things that are within the history of those inmates in prison so that they don't go on to create further victims. And so whereas I fully support this piece of legislation, I also fully support any move that we may have to assist in the rehabilitation or in the restorative nature of programs that might be run before the prisons. And I want to pick up on something the previous speaker said, and that was he was talking about, for instance, that counselling for the victims of sexual abuse and other abuse have traditionally had their funding for that counselling paid for by ACC. And for a number of years now, especially since 2003, there has been report after report go to ACC and ask the question, is ACC actually the agency that should be dealing with these matters? And the throwaway line that he used, well, this isn't an accident. And actually, if you scrutinise it, it isn't an accident. But what we do know is that successive governments, in spite of that fact, have allowed ACC to become the provider for all those things, all those counselling services, when they would have quite rightly and quite justifiably sat more appropriately, for instance, under a mental health cap or under an MSD cap. And that's where it should be. Now, I take the point of Ms Pillay, who's calling out right now, and say, we don't care. We don't care whose bucket it comes out of. We don't care whose bucket it comes out of, as long as the taxpayer is the...
Point of order. Lynn Pillay.
Mr Speaker, I take issue with that. I did not say we don't care. I said this government's cut the funding.
No, that's a debating point.
Well, I just want to make it quite clear that I wasn't saying that she wasn't saying that she wasn't saying.
Point of order. Point of order, the Honourable David Parker.
Point of order. Mr Speaker, what recourse does the opposition have when a government member deliberately misrepresents an interjection from the opposition?
If the member has taken offence under Standing Order 116, if the member has taken offence under Standing Order 116, she can ask and state her objection. But in terms of a debating point, you cannot litigate a debating point. That's a matter of debate, whether the member likes it or not. But if the member has taken offence, Standing Order 116 allows for her some recourse.
Mr Speaker, Point of order, Mr Speaker.
Point of order in play.
Mr Speaker, I have taken offence, given that that is certainly not what I said,
No,
and it is
we're not getting into the debate or whether it's right or wrong. I hear the point. I'm asking the member to withdraw the comment.
I withdraw and apologise.
Chester Boris.
And I apologise because I wasn't clear enough in what I said. And so because I didn't say, and I certainly didn't intend to say, that the member had said we don't care or imply in any way that people on the other side of the House or any other part of the House don't care. The point that I was trying to make is that we as citizens of this country don't care who or what bucket, what portfolio, what government agency gets dipped into to pay for funding for counselling. We only care that it is funded. Surely she has no complaint about that, because we quite rightly expect that where someone has been abused as a result of an attack, whether it be sexual abuse, physical abuse or anything else, if there is a need for counselling, then the wherewithal to cover the cost of that counselling will be met by the taxpayer. Now, my criticism has been that we have traditionally allowed ACC to do that when quite rightly it fits within other portfolios who have escaped that. And that is what the government is trying to put right at this stage. Now, getting back to this particular bill, the fact is that it will receive support from across the House, and so it should. But the point that I'm trying to make is this. While we run around within the criminal justice area, shutting doors on rights that are free and democratic rights in a civilised society that are incumbent on the state to provide for those people in its custody, we must remember the other side of their offending, which needs to be addressed. To leave them without access to rehabilitation, as successive governments have done and we are addressing now, was wrong. We need to do that. We need to recognise them for the people they are, and all the things that interact on their behaviour and on their existence to exhibit in offending against victims of crime. And I hope that at some stage this House will bear some scrutiny as to exactly what we provide for those people behind the bars, as closely as we scrutinise what we provide for those outside. Thank you, Mr Speaker.
Call in, Pillay.
Thank you.